Hey everyone, वेलकम टू माय चैनल फीलियर जितेश। मैं आज आप लोगों के लिए पॉलिटी के लेक्चर्स बहुत ही एक फेमस कोचिंग के अपलोड कर रहा हूँ। प्लीज़ कोई स्ट्राइक कोई कंप्लेन मत कीजिएगा, ये सिर्फ उन लोगों के लिए हैं जो अफोर्ड नहीं कर सकते हैं। मैं पहले ही माफ़ी मांग रहा हूँ, बाद में आप लोग ये मत कहिएगा कि आप चोरी कर रहे हो, ऐसा कर रहे हो, वैसा कर रहे हो। देखिए, मेरे को भी कहीं से मिले तो मुझे लगा कि उन स्टूडेंट्स के लिए डाल दिए जाएँ, जो अफोर्ड नहीं कर सकते। मैं भी उनमें से ही हूँ एक। मैं चाहता हूँ कि आप लोग इसका भरपूर इस्तेमाल करें, अच्छे से पढ़ें। दीज आर दी बेस्ट लेक्चर्स एंड मैं भी इससे पढ़ रहा हूँ, आप लोग भी इससे पढ़ो। एंड कोशिश करूँगा जल्द से जल्द सारे लेक्चर्स डाल दूँ। तो प्लीज़ अच्छे से पढ़िए। अब सही समय है सही से तैयारी करने का, तो अच्छे से तैयारी करिए। चलिए, आई होप यू विल लव दी लेक्चर्स। प्लीज़ लाइक शेयर एंड सब्सक्राइब माई चैनल।
Any problem in yesterday's lecture? कोई concept, something which you tried to understand but could not? Which of the above law or laws is are not included in the Human Rights Declaration? You know Human Rights Declaration or not? Universal Declaration of Human Rights. Universal Declaration on Human Rights, which law or laws are not part of that declaration on human rights? Access to public service. All three are part of the declaration. Okay? This question has come in examination. Means these three rights have been, apart from many other rights, these three rights have been considered to be recognized human rights in the Declaration on Human Rights. See, now if this question comes, you must not have read what is the Declaration on Human Rights, or somebody might have read. Okay? Then in that case, this is something kind of a dicey thing. Remember, this is civil services prelims. Out of 100 questions, it will not be a scenario that out of 100 questions, you will be knowing 99 questions or 95 questions. Okay, somehow you have to use the technique called as elimination also. And to some extent, you have to depend on the voice of your intuition also. But then voice should come from reading. For example, if I have read something, I encounter a very new question, then I will not attempt it blindly. I will attempt it without actually knowing the correct answer. But I will apply the knowledge from some other area which has repercussion on this question. बिल्कुल blank रट्टा भी नहीं लगाना है. Okay, now you people are very correct. This question, this option seems to be wrong, but then this was right. ठीक है? Anyways, बताओ सर, where did we stop yesterday? कल कहाँ रोका था? हाँ, फंडामेंटल राइट्स तो शुरू किया था, रोका कहाँ था? पेज पलट के देख रहे हैं. Why fundamental rights are called as fundamental rights? This was my question. हाँ जी, ये आंसर देंगी, बोलो. First point, why the name fundamental given to fundamental rights? Very important class today's. हाँ? Basic for what? भाई फंडामेंटल का मतलब क्या है? फंडामेंटल इज द बेसिक. Human to survive नहीं. Yes, these rights are must basic for somebody to achieve his full potential. When I gave you example also, right to education. If somebody is not going to school, how can he prove that he is very strong in mathematics or he can become a good scientist? Understood or not? What was the second reason, sir? पढ़ के नहीं बोलना है, बोलो. Second reason, they are sacrosanct. Sacrosanct means they are extremely important among all the rights fundamental rights are the most fundamental, most sacrosanct, most important. They are must, they are again the basic to develop a civilized society. अगर एक अच्छा समाज बनाना है तो you have to have these kind of rights. Without these rights, there will be no difference between India and China. Militarily, we economically also we might be far ahead of China, but then we are getting appreciated in terms of appreciation of human rights. China is not, because we provide explicitly these fundamental rights, and so we are considered to be relatively a better civilized society than these countries, North Korea or even China. Understood, sir? Okay, next point. Difference between fundamental right and other legal rights. I explained this, I did not dictate. Okay. What first difference, sir? They are? But they are also justifiable in the court, no? Enforceability. From where you got fundamental rights? Constitution. From where you got these other legal rights? Power of the parliament to make the law. दोनों में difference हुआ नहीं हुआ? These are coming. I gave you example also that, for example, this RTI ले लो, right to information. Is it mentioned in the constitution? No. You have this right because parliament just made a law which was called as right to information. और इवन नरेगा, कल ही एग्जाम्पल दिया था ना मैंने आपको. नरेगा इज अ लॉ विच गेव यू राइट टू वर्क, बट इज इट मेंशन्ड इन द कॉन्स्टिट्यूशन? नो. Whereas these fundamental rights are precisely rights which are mentioned in the constitution. पहली बात, they are enforced because of the constitution directly, and they get enforced by the provision of the ordinary law. Of course, ultimately by the constitution only. But लिखने के लिए आप लोग ये लिखोगे. Second, if your fundamental rights are violated, what you can do? सीधा, you can approach the Supreme Court, which is the ultimate court in this country. Whereas if these rights are violated, you may go to a lower court. Okay. Now see, nature of fundamental rights. Give the heading nature of fundamental rights. बोलो सर. No. He can go to lower court also. No binding, no foundation on him. ठीक है? Nature of fundamental rights. Be alert throughout the 3 hours today. बहुत जबरदस्त बात होने वाली सर आज. Nature of fundamental rights. आपसे एक क्वेश्चन पूछता हूं. My question is, using your fundamental rights, do you get protection against the action of state or private party also? Both state or private party? Both. Question दोबारा सुनो. Regarding fundamental rights, do you get protection against the actions of state? State means executive, legislature or any other body which is somehow state का मतलब क्या आप ये भी समझ लो. See, now in the section of fundamental right, when I am mentioning the word state, it has a specific meaning. Okay, state means any body. To be specific, let me name few, like union, parliament, state, legislature, executive, union or state, local government or any other body which is funded by state. अगर गवर्नमेंट, आप एग्जांपल लो, डीटीसी का नाम सुना है आपने? डीटीसी, दिल्ली ट्रांसपोर्ट कॉर्पोरेशन. इज इट नॉट वेरी मच फंडेड बाय द गवर्नमेंट? दिल्ली गवर्नमेंट इसको फंड कर रही है, सो इट विल ऑल्सो बिकम पार्ट ऑफ स्टेट. इफ यू आर नॉट गिवन अ गुड सर्विस or somehow DTC service is violating your fundamental rights, then you can go directly to Supreme Court. They cannot say, no, we are not part of government. We are only an arm of government. Even if there is an arm of government, that will be covered under definition of state. ये कौन से article में? In which article? 12. This is given in your notes of Vision IS also. So don't worry. No need to write also. Just understand this. ठीक है? समझ लो इसको. State means any organ of the government, whether it is the legislature, executive, or local government, or any body which is financed by the government. कोई भी ऐसी body जिसको government fund कर रही है, substantial funding, or even a government or even a private body which is not actually properly funded by the government but it is working for government, वो भी state मानी जाएगी. Take this example. Have you heard of this name? It's a company, Carvi. Carvi. For example, you have to have your PAN card made. PAN card बनवाया ना आपने. So this is a private company which is giving this service to government. Government has outsourced the work to Carvi. कि भाई जिसको PAN card बनवाना है, तुम उसको बनवा के दो. You collect the documents and we'll issue the PAN card through you. ठीक है? Means it is not actually part of the government. But according to this definition, first of all, this body is giving service to you on behalf of state. Government ने खुद एक department नहीं खोला. They outsourced this work to a private company called as Carvi. उनको ये काम दे दिया कि भाई तुम बनवाओ लोगों के documents, PAN card or some other documents. ठीक है ना? Now tomorrow they have all of your information. Tomorrow if they sell that information to the third party, okay, or somehow there is a leakage in their system that your information gets revealed to somebody else or it comes in public domain, then you can sue Carvi. English. You can sue Carvi because now Carvi is part of state and it has violated your fundamental right. by right to privacy था ना आपका, वो expose कर दिया उन्होंने. So it is also arm of state even if it is a private company because it is working for your welfare on the behalf of state government. Understood? कोई भी body, either it is partially or substantially funded by government or it is working for larger public interest, that will be coming in the definition of state. And if these bodies somehow violate your fundamental rights, then you can go to Supreme Court also, as your fundamental rights have been violated by any other body. And there is no exhaustive list कि भाई यही है. Sometimes the language of law is such, they leave a room for interpretation in the future. For example, they will write or any other authority. Giving the definition of state, they will write state means legislature, executive, local government, PSUs or any other body substantially funded by government. अब any other body का मतलब क्या है? It can be interpreted from case to case basis. And who will interpret that? Supreme Court. समझ में आई बात sir? This is state. Now this will continue for the whole chapter 3 of the constitution, which is fundamental rights. Clear? Nature of fundamental rights. First, my question was, are fundamental rights? सवाल तो यहाँ था. Are fundamental rights providing you protection against the actions of state, or are they giving you protection against the action of non-state bodies also, like कोई private individual? Both. In most of the cases, you will get, मतलब क्या protection का मतलब क्या है? If state is violating your fundamental rights, you will go to the court. भाई मेरे fundamental rights state ने they damaged it. You go to court and give justice, get justice. Even if a private individual is taking away some of your fundamental rights, not all, specific fundamental rights, then you can go to court. Tell me which is that fundamental right which if violated by a private individual can attract you going to Supreme Court. 15 to 16 मत बोलो. Untouchability, for example, if somebody, even an individual, he is showing untouchability against you, can you not go to court? है ना? Or another example, exploitation. If these people are working as a bounded labor for me, can they not go to Supreme Court that he is making us work like a bounded labor? And in that case, even if I am not state, I am only an individual, then also Supreme Court will act against me to restore their fundamental rights. Means in this case, Supreme Court is acting against an individual. Right to life. If somehow I am interfering in the right to life, then again Supreme Court will take action against me. Answer अगर pre में आ जाए तो दोनों लिखना. Fundamental rights are protected against the action of state as well as private individual. लिख लो इसको first. Fundamental rights provide protection. Fundamental rights provide protection only against state action. लिखो. Only against state action and not against whom? Bolo. Not against private individual. I know this is a tough time after having a good lunch. It's very difficult to remain awake. Against private individual except in case of इनको छोड़कर, except in case of first rights relating to abolition of untouchability, right against exploitation, and right to life. Fundamental rights are absolute. सर आप बताओ कोने में fundamental rights are absolute or they are not absolute? हाँ जी बोलो. Not absolute. What is the meaning that they are not absolute? बोलो तेज बोलो. They are, देखो absolute क्या है? मार्केट में आपने स्कीम देखी है ना? You must have seen many schemes in market. ऐसा लिखा रहता है ना कई जगहों पे, get a new car at the rate of ₹1 or travel from Delhi to New York at 500 rupees. But then if you read it very carefully, they have put a star also. Condition applies. खत्म खेल सारा. सपने यहीं टूट जाते हैं. Same is the case with fundamental right. They have given some rights to you, but then again they put a kind of star. For example, there is one fundamental right. I have freedom of speech and expression. Now I am having a fundamental right. Nobody can stop me from speaking something. However, again, इसके साथ क्या लगा है? Star. I cannot say particular thing which can hurt the sentiments of particular other entity. And this is very much in news. For what reason? नहीं JNU तो ठीक है. Word. Rahul Gandhi case, defamation. Now, you on one hand, you say that you have freedom of speech. On other hand, when I say that he's a fool, then you imprison me. Because I must know that there are restrictions also along with every fundamental right. They are not absolute. Understood this or not? Beyond, limit is set on every fundamental right. If you cross the limit, you attract punishment. And defamation is very much in news. So be alert on that. However, there is one fundamental right with which there is no asterisk. Star नहीं लगा है उसके अंदर. एक है fundamental. कौन सा है वो? Which one? Right to life. Which one? Which is that हाँ वो 21 है, but then which is that fundamental right which is absolute in its language and implementation? Some people are saying right to life. Any other answer also? हाँ जी. यार आई एक्सपेक्टेड दिस आंसर फ्रॉम यू पीपल. आर्टिकल कौन सा? एक मिनट. You are such a bright batch. You give so many difficult answers. और ये easy answer है. Untouchability. Excellent. Which article? Article 17 is given in absolute form. Untouchability is banned in whatever forms. उसमें कोई condition नहीं लिखी है that untouchability is banned. However, if untouchability is in this form, that is allowed. No. Untouchability in every form is banned. ये है absolute. Otherwise, if you see, even right to life is not absolute, or is it? You murdered somebody. Will you say, no, I have right to life, now state cannot take away my life? Okay? No. Restrictions वहां भी हैं. Understood, sir? लिखो इसको. Fundamental rights are not absolute. उसमें भी emergency लगी हुई है. For example, there is emergency. You cannot go to court. No, then. Fundamental rights are not absolute. Brackets, except for Article 17. Fundamental rights are not absolute, brackets, except for Article 17, untouchability. Bracket close. That is, there are reasonable restrictions on them. Reasonable restrictions on them. Fundamental rights are negatively worded or positively worded? Both or none? Negatively worded? Both. Both का option हमेशा safe रहता है. Okay. There are few fundamental rights. उनकी language देखो sir. गौर फरमाए language पे. There are few fundamental rights which, according to their language, they are preventing the state from doing something. समझ रहे हो? कुछ fundamental right ऐसे हैं जिनकी language अगर आप पढ़ो तो आपको लगता है कि वो state को रोक रहे हैं. There are few fundamental rights which, according to their language and of course the spirit, they are preventing state from doing something. Okay. For example, which article? Article 14. State, देखो उसकी language क्या है? State shall not deny to an individual the not आ गया ना इसके अंदर, not आया नहीं आया, means state cannot deny an individual right to equality. Understood or not? इसमें negative orientation है कि नहीं है? Means this right, this particular right is preventing state from providing something to state. Understood or not? एक ही है Article 16 clause 1. What is it? 16(1) क्या है? Article 16 सर बोलो. Sixteen one says state, I'll discuss each of them later on also, don't worry. ये तो सिर्फ एक ट्रेलर है. State shall provide equal opportunity to in public employment to everyone. State को देना है. Did you see any negative word here? No. It is not preventing state. It is asking state to do something. इसमें तो कोई दिक्कत ही नहीं है. So we can distinguish the fundamental rights in two categories. One, which are negatively worded, having negative connotation or preventing state from doing something, whereas other, they are asking the state to do this. बाहर घूमने नहीं जाना है, negative orientation. मंदिर जाना है, positive orientation. लिखो. Fundamental rights are divided in two groups. First, which are in the nature of negative injunctions और नेगेटिवली वर्डेड, लिख लो सर आपके लिए ये, और नेगेटिवली वर्डेड, prohibiting the state from doing certain acts example article 14, 16 clause 2. What is 16 clause 2? Anyone? You can say. Yes, state shall not discriminate among people with regard to employment on the basis of this. समझ रहे हो? State discriminate नहीं करेगा. Okay? और 16(1) की language क्या है? State will provide equal opportunities. Okay? See, if you see, actually both the things are same only, but then they have significance, legal significance. So both have been given here. Understood? दोनों positively worded है. 16(1). Second group, fundamental rights. Second group means which are positively worded. Fundamental rights in the nature of positive commandments. In the nature of positive commandment means the fundamental rights are commanding the state, do this for people. Fundamental rights in the nature of positive commandments or positively worded, conferring certain rights or benefits upon individual example article 16(1). Any other example where state is being asked to do something? Positively worded, sir. No problem. As we proceed, you can understand there. When I'll take each and every article. 19, yes, very good. Yes, sir. What is the meaning of judicial review? समझ लो, and later on you can write also. But then first understand this concept. Anyone, what is the meaning of this word judicial review? And this is very much again in news, judicial review. What is the meaning of the word judicial review? Okay. Very good. Only it can act against the parliament or any other body also? Bas. If administration is doing something, do not write, listen. If administration is doing something and if that something is wrong, then state can prevent that administration wing from doing that thing. Okay. If any organ of administration, whether it is the executive or legislature or any sub bodies, okay, they are doing something. By executive ke to wings hai, police, for example, this is the wing of executive or legislature? Executive. Now, if any executive or legislature or any of their wing, they are doing something which somehow violate your fundamental right or otherwise they are against the values of constitution, then judiciary can review that action or go into that action and then approve it or disapprove it. Now, this action of judiciary is called as judicial review. Review करते नहीं करते हैं? You saw Sultan, then you pass on your review or not? बढ़िया है कि नहीं है? This is like something has happened and now you are studying whether that something was right, wrong, good, bad, constitutional or unconstitutional. ये है review, as simple as that. ठीक है ना? But then इसमें कुछ tell me which is that article of constitution which gives this power of which is the article of constitution which gives the power of judicial review to the judiciary. चलो 13 मान लिया. Some people said Article 13 gives the power of judicial review to judiciary. You understood what is judicial review? What is 13? Article 13? What is it? बोलो. हाँ, violation of. बोलो बोलो complete बोलो. If there is a violation, ये याद रखना, Article 13 is only with respect to fundamental rights. Article 13 gives the power of, do not write, listen. Article 13 gives the power to judiciary to review the action of administration regarding violation of only and only fundamental rights. If any action of administration, whether legislature or executive, is not a violation of fundamental right or it has nothing to do with fundamental right, then in that case, Supreme Court will not review that action using the power under Article 13. Article 13 gives the power to judiciary to review the action of administration only and only with respect to fundamental right. You understood it? Whereas, is there any other provision also which is providing the power of judicial review to judiciary? 32 and 226. They also provide the power of judicial review to Supreme Court, but it may not relate with fundamental rights. Power ये भी judicial review की है, but it may not relate with the fundamental right. See, I have not even touched this article, so I will not elaborate on this. When you read this article, you will understand what I am saying. So first you write and then I will again explain. But then when you are writing, please read what you are writing. सिर्फ लिखने मत शुरू करना. Read and then write and have an understanding. That will make your work easier. Write down. पहले लिखो इसको. Judicial review means the power of Supreme Court and High Court to declare a law unconstitutional and void if it violates one or more provisions. If it violates one or more provisions of constitution. Bhai, there is so much apart from fundamental right in the constitution. आप ये देखो, for example, right to property. Example दे रहा हूं, right to property, right? You have this right to property as your constitutional right, right or wrong? Now, if tomorrow Parliament makes a law which takes away your right to property, then will you not go to court? कोर्ट में आप जाओगे ना कि भाई ये तो हमारा राइट टू प्रॉपर्टी था एंड गवर्नमेंट हैज कम आउट विद द लॉ व्हिच इज just like that violating the right to property. The government has not amended the right to property first. They have made a law which is violating this right to property. So you will go to court. And when court will take a decision whether this law made by the parliament which is violating this right to property is right or wrong, ये action क्या है? Judicial review only. Now is this relating to fundamental right? No. Right to property is not a fundamental right. Okay. So what I mean to say is that judicial review can happen in the cases which are not relating to fundamental rights. Judicial review तो पूरे term को बोलते हैं. Any action of administration which is reviewed by judiciary that it is constitutional or unconstitutional is called as judicial review. Now that may relate to fundamental rights or that may not relate to fundamental rights. ठीक है सर, लिखो. सब कर सकते हैं सर. जुडिशरी, the power of judicial review is available with courts power of judicial review is available with the court against the action of बताओ सर, legislature, executive or both or none? Both. Very good. Is available against the legislature and the executive actions. Against the executive and the legislature's action. In which part you will find this word judicial review explicitly? कहाँ लिखा हुआ है? Nowhere. मजे की बात ये देखो. No part of the constitution explicitly has used the word judicial review. And apart from article 13, 32 and 226, 32 and 226 की अभी चिंता मत करो. Okay, it is the power of Article 32 is the power of Supreme Court to restore your fundamental rights in case they are violated by the administration. ठीक है ना? ये Supreme Court की power है and this relates only to fundamental right. Remember this. ठीक है ना? Whereas Article 226 is the same power given to High Court. If High Court is restoring your fundamental rights, it can do so by issuing an order, and that will be done because High Court has been given this power under Article 226. And if the same job is being done by Supreme Court, it is because of the power given under Article 32. But the difference is that 32 relates only with fundamental right and 226 with other legal rights also. ये समझ में आ गया आपको? So what I was explaining was that nowhere they have used this word judicial review, but from various provision we get to know that judiciary has got this power. All are independent in their own sphere, but when judiciary is keeping an eye on the action of legislature and executive, is it not a kind of special power? हर बात के लिए, every action committed by legislature and executive, judiciary is watching them, right or wrong? So it puts judiciary at a higher pedestal or not? Little bit higher pedestal compared to them, means it is a very typical and very sensitive issue, judicial review. It's a great power given to judiciary. Is it not making judiciary a little bit higher compared to legislature and executive? But then see the irony, Constitution is not explicitly giving this word judicial review to empower the judiciary. But from where you came to know that judiciary is having these powers? कहाँ से आपको पता चला that judiciary is having this power that it can keep an eye or it can review the action of legislature and executive? Provision of the constitutions. For example, Article 13 अभी बताया, Article 32, another article. Are these only three provisions where you came to know that judiciary has the power of judicial review? क्या ये सिर्फ 3 आर्टिकल है या कुछ और भी है? This is my question. There are commentaries also, like, or don't you have this concept called as supremacy of the constitution? That constitution is to be maintained supreme, उसको हमेशा ultimate value देनी है. But who will ensure that constitution is being respected or it is not violated? ये कौन ensure करेगा? Judiciary. And how? Judicial review. Parliament makes a law which undermines the power of constitution or which undermines the value of the constitution. Parliament ने ऐसे एक law बना दिया. For example, who will interpret that actually this action of legislature is in violation of the constitutional spirit or it is bringing down the sanctity of constitution? कौन decide करेगा? Judiciary. Through what? Judicial review. देखो question why I am explaining this so much is that question might come that which of these provisions is not providing the power of judicial review to judiciary. वो ऐसा question पूछ देंगे. They might, in that case, you will write only 30 to 26. You may not choose this, but then remember this is also a provision which is providing indirectly the power of judicial review to whom? Judiciary. There is another concept called as the concept of limited government. Okay, limited government का मतलब क्या है sir? What is the meaning of limited government? Limited government का मतलब बताओ. Limited government, I gave you example of North Korea also. The army chief was yawning in front of the president and he was tied to a cannon and blown. I mean, is this the way constitution should work? No. This is unlimited government. A government which is acting as per the rules and within limit is limited government. But then who will actually tell us that this government is acting within its limits? कौन बताएगा? Judiciary. And when judiciary is telling us so, judiciary is telling us so after judicial review. भाई वो पहले ये भी तो स्टडी करेगा what are the actions committed, what are the wrong committed by the administration. तभी तो आपको बताएगा कि ये काम सही था या गलत था. Means even the concept of limited government is providing the power of judicial review. Understood? Write down. Complaint पे generally होता है, but then nobody can prevent judiciary from taking it suo motu also. Okay, write down. Because if judiciary starts taking these cases suo motu, then in that case it might appear that judiciary is taking the power in its own hand and it is trying to destroy the principle of checks and balances and separation of power. Okay, write down. Judicial review is mostly implicitly, please underline the word implicitly. Judicial review is mostly implicitly provided in the constitution. Explicitly बहुत कम जगह दिया हुआ है. It is mostly given implicitly. Implicitly मतलब in a hidden way. And is not directly expressed in the constitution and is to be inferred under Article 32 and 226. You write in front of 32. 32 is the writ jurisdiction. Writ is kind of an order. If Supreme Court issues an order, do this, then that can be called as writ. Okay, writ jurisdiction of Supreme Court. I'll explain that in detail. Don't worry. अभी इतना ही लिखो. Writ jurisdiction of Supreme Court. Jurisdiction means power. Writ jurisdiction of Supreme Court. 226 is writ jurisdiction of High Court. It is also implicitly seen in the doctrine of limited government, supremacy of the constitution, rule of law, separation of powers, fundamental rights, etc. Article 13 explicitly means openly confers the power of judicial review on courts with respect to fundamental right. Judiciary came to know that administration is doing something. Administration means here legislature or executive at any level, center or state. Okay. Now judiciary came to know through media or some other people that administration is trying to do something. Means legislature is about to bring a law or executive is about to do something. एक rumor ऐसी चल रही है और actually they are being seen doing this. ठीक है, वो कुछ करने वाले हैं. Can judiciary apply judicial review at that point of time? Only after it becomes an action or it is realized, judicial review can take place. See, NJAC legislature was going through all the procedures to form NJAC, National Judicial Appointment Commission. You know NJAC or not? NJAC is a body, or was actually a body, which was formed to appoint the judges or transfer the judges in Supreme Court, High Court. Okay. Now this NJSC was actually brought by the legislature. Now Supreme Court was seeing this happening. Many people said it is unconstitutional, because when you take away this power to appoint the judges from judiciary and you give it actually to a body in which prominence is given to executive, then in that case independence of judiciary can get hurt. But then judiciary and somebody filed a case also that this bill which is being passed or which was passed by the parliament ने pass कर दिया था, but then अभी presidential election नहीं आई थी. Then somebody filed a case in the court, Supreme Court directly, that the NJSC which is passed by the Union Parliament is actually a violation of constitution, because NJSC will hurt the independence of judiciary. तो इसको आप nullify कर दो सर अभी. Judiciary said, have some patience, this is still not an act. Act मतलब law. अभी ये law बना नहीं है. It is in process of becoming a law. Let them do all the effort. Time कर लगाने दो उनको. Let them make it a law. उसी दिन struck down कर देंगे. Understood? Judicial review is done after a bill has become an act, or actually executive has committed something. Okay? And this is generally done when somebody files an application or writ. However, there is nothing written in the constitution that it prevents Supreme Court from taking the action on its own. Prior नहीं, अपने आप, even without somebody filing a writ. कहीं कोई रोक नहीं सकता Supreme Court को. But generally Supreme Court carries out judicial review when somebody files a complaint to judiciary. Right now, judicial review is applied after an act or order comes into force and not in bill stage, and not in bill stage. Second, ordinarily the courts apply judicial review on the basis of a petition filed and not suo motu on its own. इसका मतलब है अपने आप खुद. Judicial review has helped the judiciary to protect itself from the possible encroachment on their powers by executive and legislature which is essential to maintain their what? Independence and neutrality. Neutral रहना भी तो जरूरी है. If I am being appointed by executive, I might get biased towards them. So I struck down it using NJC. I struck down NJC using judicial review power. Second benefit sir आप बताओ. What is the second benefit of judicial review? पहली बात तो ये है that judiciary will save its independence and neutrality. What is the second benefit of judicial review? अगर मेंस में लिखने को आ गया, what will you write? They give these kind of questions also. तब सोचने का टाइम नहीं मिलेगा. See, let me tell you this also. Do not take mains very lightly. Answer, I mean, if they are giving an assignment, try to write that assignment with full integrity and try to see the time also which you are taking in every assignment. Because right now, the kind of mains they are preparing, you will have no time to sit and think. In fact, take 2-3 pens. अगर एक पेन गिर भी गया तो do not pick it up. ढूंढने मत लग जाना उसको. दूसरा पेन निकाल लेना. Time नहीं है sir. Because it happens, many people who are very brilliant otherwise, they applied for the first mains because of their lack of experience regarding the criticality of mains. They exploited the time like anything. जैसे स्कूल में होता था. After every 1 hour they were going to the washroom. चलो यार थोड़ा घूम के आते हैं. 3 घंटे का पेपर. No, now you don't have that liberty, and you don't have the liberty to sit and think. Contemplation का time नहीं है. सोचने सर एकदम से. I am saying what is the benefit of judicial review? First point given by me. Second point will be given by him. बोलो. बोलो सर जल्दी बताओ. Exactly. Use this word. Constitutionalism. How will we have constitutionalism unless judiciary is given that power to review the action of executive and legislature? Constitutionalism मतलब sir limited government. Constitutionalism means a system where government is limited or the powers of government are defined and they work according to those powers only. ठीक है ना? Right now. Judicial review also helps the court. Second, it also helps the court to act as a protector of fundamental rights, comma, to act as a protector of fundamental rights, comma, ensure constitutionalism, helps in validation of the laws passed by state. Validation means whether these laws are according to constitutional provisions or not. Division of power, rule of law, etc. वो भी मेंटेन होता है इससे. Is judicial review part of basic structure of constitution? You know what is basic structure of constitution? Sir, what is the meaning of basic structure of constitution? इसका मतलब क्या है? आइडियोलॉजी और कोर आइडियोलॉजी, द एसेंस. ठीक है ना भाई? आप ये देखो, आई गिव एन एग्जांपल. नाउ यू हैव जस्ट स्टार्टेड द कोर्स. व्हेन यू विल फिनिश द कोर्स एंड यू विल गो थ्रू द लेक्चर्स ऑफ आर्ट एंड कल्चर, देन यू विल कम टू नो दैट 2 kinds of school of sculpture are there. Gandhara school and Mathura school. Okay, they project Bhagwan Buddha in different way. One school projects him like a hero, muscular वगैरह दिखा के एकदम थोड़ा सा बेटर बना देते हैं उनको. The other school is not projecting him in such a fleshy way. ठीक है ना? But then, even if they are projecting the same person in different way, are they actually hiding the halo effect in Lord Buddha? No. If you see in both the cases, you get the divinity feeling whether you see the painting made by Gandhar school or Mathura school, because this peace, the tranquility, the divinity which is expected from Lord Buddha or any other divine power is seen in both the cases, because वो जो peace है, वो divinity है, that is the core of भगवान बुद्ध. उसको वो छेड़ेंगे नहीं. भाई देखो, अगर भगवान बुद्ध को उन्होंने ऐसे बना दिया, ये कोई बात हुई? You are not getting the feeling of divinity from this feature. So even if they bring variation, in one painting you get his hair curly, on other he might not even having a hair, but then he will still be throwing a kind of peace which you expect from Buddha. किसी भी स्कूल ऑफ थॉट को पकड़ लो, वेरिएशन तो दिखाएंगे, मगर कोर को टच नहीं करेंगे. दैट कोर, द पीस which reflected by Lord Buddha will be seen, because वो peace, वो divinity is the core of भगवान बुद्ध. Similarly, Indian Constitution is having a core, उसकी कुछ essence है. You take away that core, Indian Constitution will become just like Pakistan, China or any other country. Something which makes Indian Constitution Indian is the basic structure of Indian Constitution. जैसे कि example, what will you tell me as an example of basic structure of Constitution of India? Secularism, democracy, socialism, separation of powers. Okay, is sub basic structure. I'll take that separately. Tell me in which case Supreme Court said that judicial review or the power of judiciary to review the action of executive and legislature is part of basic structure of the constitution. किस केस में कहा? हाँ जी, very good. In Keshavanand Bharati case, the Supreme Court only said basic structure of the constitution should never be touched. Means ये जो basic structure का concept है, for the first time it came in which year? Very good, 1973. In which case? Keshavanand Bharati case. But judicial review, अब तब उन्होंने ये define नहीं किया ना. In 1973 they did not explicitly tell that this is part of basic structure, this is also part of basic structure. ये उन्होंने तब नहीं बताया था. In various cases they were telling. For example, judicial review is also one of the component of basic structure, was told by Supreme Court, in which case she is right. Minerva Mill case 1980. Okay, right now. Realizing the importance of judicial review, उसकी वैल्यू समझते हुए, realizing the importance of judicial review, in Minerva Mill case, Supreme Court applied, or Supreme Court said that the power of judicial review is part of basic structure of constitution. डॉक्टर अंबेडकर वॉज अ मेंबर ऑफ कॉन्स्टिट्यूएंट असेंबली, तो पता ही है आपको. ये क्वेश्चन आ गया एग्जाम में, व्हाट विल बी द आंसर? बॉम्बे पक्का, बॉम्बे प्रेसिडेंसी. ठीक है सर, लिखने के लिए है ये, देखने के लिए नहीं है, बाद में याद भी नहीं रहेगा. नॉट इन दिस फॉर्म, इन अदर फॉर्म यू कैन राइट डाउन. See, polity is such an area where there is no end to information, questions or detailing. उसका तो कोई अंत ही नहीं है. So do not feel that teacher is coming and he will just tell us what is to be read. उसके अलावा हम कुछ नहीं करेंगे. Whenever you come across a question which enlightens you or gives you a new fact, उसको रट लो, समझ लो. Because this question can actually become a part of the question or an independent question in civils. You never know. Do not stop yourself from acquiring information. Do not sit that teacher will dictate only तब हम लिखेंगे. Grab every piece of this information. जो भी बोला जा रहा है आपके लिए ही है. ज्योग्राफी चली रही है. यू नो दिस सिंस चाइल्डहुड. वैसे मुझे आज तक समझ में नहीं आया व्हाट इज लूनर एक्लिप्स. बताओ सर, व्हाट इज लूनर एक्लिप्स? इन बिटवीन हो या अर्थ बिटवीन होगा? भाई मून इज ब्राइट बिकॉज सनलाइट इज कमिंग ऑन इट, ठीक है ना. बट हेयर कम्स अ विलन इन बिटवीन अर्थ एंड इट ब्लॉक्स द लाइट. तो मून किस में आ गया? शेडो में. नाउ व्हेन मून इज इन द शेडो ऑफ अर्थ, डज इट मीन दैट मून इज नॉट देयर? भाई आप तो यहां खड़े हो and this is the day of lunar eclipse. Today you felt that no, moon has vanished from this heaven. Moon to gaya. Is it true? Even if you are not able to see the moon during an eclipse, it will not mean that moon has vanished or moon has got destroyed. Moon is there, but the only thing is that it is not actively seen. Moon dikh nahi rahe, magar moon hai to sahi. This is the beauty of eclipse. ठीक है ना? Similarly, this was such a fascinating concept that people in the law fraternity, they also acquired it. उन्होंने भी इसके नाम का एक लॉ, एक डॉक्ट्रिन बना दिया. That doctrine is called as doctrine of. Will anybody tell me what is doctrine of eclipse? हाँ जी बताओ. Very true, very true. But then let me simplify this and tell you also. ये एक लॉ है. This is a law L1. This is the law L2. ठीक है ना? Which is the bigger law? Apparently L1. It is more important also. ठीक है सर? Now as such, इधर देखो, L1 and L2, they are both law and they should exist. But somehow the provisions of constitution are such that if till the time L1 is existing, L2 cannot function. समझ रहे हो आप ये बात? एक लॉ है तो दूसरे लॉ को हम एक्टिवेट नहीं करेंगे, because the definition of both the laws are such that they contravene each other. And it is also written that this is a bigger law. Constitution में ये लिखा है that L1 is a bigger, more important law and L2 is in conflict with L1. दोनों आपस में टकरा रहे हैं. Okay, both are independent law. This is a bigger law, this is more important, and it is in contravention to L2. They are actually in conflict with each other. So what will we do? We understand one thing, that this is also a law which is important. So let's not remove it from the law book. उसको हटाने की जरूरत नहीं है. Let it be there in the law books, but we will not activate this law. We will not apply this law. And this law, L2, will be said to be eclipsed in the shadow of L1. Law तो रहेगा. Law, right or wrong? Law will be there and that law will remain dormant. Hibernation में चला जाता ना भालू, where it goes into hibernation. But इसका मतलब ये थोड़ी ना he's dead. He will again come up. When what will go? Winters will go. सर्दियां जाते ही वो जोश में आ जाएगा. The day L1 is removed from the system. भाई ऐसा भी तो हो सकता है that tomorrow we feel that यार L1 तो वैसे ही बेकार है. Let's remove it completely. What will you see now? L2. And L2 has now come out of eclipse. Understood this concept? मतलब जब तक L1 था L2 दिखा नहीं आपको, but it did not mean that it was not existing. It existed, but in dormant form, like hibernating bear or any other thing. ठीक है? But the day this contradiction is removed, ऐसा भी हो सकता है that we remove L1 altogether, or we manipulate the language, or we change the language of L1 or L2, so that the new language removes the conflict. उनमें झगड़ा ही नहीं है आपस में अब. भाई conflict होते नहीं होते दो law के अंदर. So this is called as doctrine of eclipse, that this smaller law or less important law will remain eclipsed till the time the bigger law is there. Tomorrow, when the conflict is removed, you can again use the law, but till the time there is a conflict between L1 and L2, L2 cannot be used. वो दिखेगा नहीं आपको implementation में, but law books में रहेगा वो. Understood? Now the same thing. अब एक बात बताओ, doctrine of eclipse, is it actually an instrument to cut a law or to save a law? Save a law. ये इस law को बचा रहा है. Doctrine of eclipse is actually giving protection to a law. रहने दो उसको, मारो मत. ठीक है सर? This is it. Now what happened? Now this was a separate discussion. इसको सिर्फ mind में डालो. And now I'll apply that. Anyone, what is Article 13 Clause 1? बताओ. हाँ जी बोलो. Be now very alert, because आज understanding हो जाएगी इस पे. In future, when you might read that again, it might be very difficult. So be alert and focus on what is being done. Okay? She's saying that Article 13 Clause 1 deals with pre-constitutional law, means the laws which were formed before the constitution commenced. कुछ कानून तब भी तो बने थे जब constitution commence हुआ था, उससे पहले. Few laws were made before constitution got commenced. What was the date of commencement of the constitution? ठीक है? On this date constitution commenced, but did we not make many laws before this date? उससे पहले हमने कितने law बना दिए थे? Right or wrong? So Article 13(1) is talking about these laws only which were made before 26 January 1950, the date when constitution got commenced. Constitution जब शुरू हुआ, enforced तो 26 जनवरी को ही हुआ था ना. Okay, now see 13(1) क्या बोलता है? 13(1) कहता है in Hindi and in simple language, do not write, just focus. 13(1) says that any pre-constitutional law, if it violates the fundamental right of Indian Constitution, then this pre-constitutional law will be null and void. खत्म. Eclipse नहीं सर. ये नहीं कि मैंने eclipse पढ़ा दिया तो यहां भी आप वही बोलोगे. 13(1) is not saying eclipse. Nowhere. It is clearly saying that every pre-constitutional law, see, this is the case, we made many laws before constitution got commenced. अंग्रेजों के टाइम से भी चला आ रहा था, and we did not scrap them even after 26 January 1950. उनको हम चला रहे थे. They were pre-constitutional law. If any pre-constitutional law completely or partially it violates the fundamental right, then this law should be nullified, unconstitutional and void. ये था Article 13(1). ठीक है ना? I give an example, only an hypothetical example. See this. For example, there is a law which says, ये पहले अंग्रेजों ने बनाया था. For example, in 1920s, Britishers made the law that if you want to open a press, अगर आपको प्रेस खोलनी है, press you know or not? जहाँ छपाई होती है, इस्त्री नहीं है, प्रेस. If you want to open a press, you have to have, first, you have to have take permission from government, and tomorrow, if government feels, it can confiscate your press without even giving you notice. आपको बिना बताए आपसे प्रेस भी ले लेंगे and they will put you behind the bars till the time they want. ये कानून बना दिया उन्होंने. Now see, if you can see, this pre-constitutional law means which was formed before 26 January 1950. This law is having three parts. Part A, Part B, Part C. Part A matlab, what is Part A? If you have to open a press, take permission. Part B is, they can close your press at any point of time. Part C, you can also be put behind the bars without even giving you the reason why you are being put, just because you were running that press. Understood? ये तीन part है इस law के. Now first part, do you think, now we are in this new millennium, do you think that to open a press when you take permission, is it the violation of your fundamental right? लगता है आपको? Yes or no? No. इसमें कौन सा violation हो गया? Taking permission. It's not a violation. In fact, you were taking permission before 1990s. हर चीज के लिए permission थी, license राज. Okay. So part A is okay with fundamental right. It is not violating fundamental right. No contradiction with fundamental right. But don't you think there is a violation of fundamental right in part B? What is the violation? 19(1)(a). 19 clause A, clause, subclause A. 19 clause 1, subclause A. Understood? Now, when Britishers made this law, which we are continuing right now also, ये assumption है, that they can take away your press at any point of time. Is it not a violation of your fundamental right? ये तो है ही. भाई, fundamental right says that you have freedom of speech and expression, and press is the way to express yourself. Third thing is they can put you behind the bars even without giving you notice. Is it not again fundamental right violation? ये भी है. Because as per the law, fundamental right, you have to be given the reason क्यों आपको arrest किया गया. ठीक है sir? Means this is a law in which there are three parts. Part 1 is in consonance with fundamental right. However, the other two parts are not in line with constitution, not in line with fundamental rights. बोलो sir. अभी क्या करोगे आप? As per सुनो मेरी बात ध्यान से. As per Article 13 Clause 1, original Article 13 Clause 1, the whole law should have been scrapped. Because Article 13(1) क्या बोलता है? Article 13(1) says any pre-constitutional law which is in conflict with fundamental right should be scrapped. उसको हटा दो. तो as per the Article 13 Clause 1, we should remove this whole law or not? But see, this is the wisdom which can only be seen in the Supreme Court of India. Supreme Court said that, see, when you have made a law, there must be some logic behind it, making the law. I'm not justifying the law, I'm just giving the reasoning. तो एक काम करते हैं, let's not scrap the law altogether, or let's not scrap that part which is conflicting with fundamental right. Let's keep it dormant. Hibernation में भेज दो इसको. Tomorrow when this conflict is removed by any means, then we can again revive these laws, because somehow there must be some rationale in this law. AFSPA, for example, Armed Forces Special Power Act, okay, it is 1948. Now it is violating fundamental right. If you see that way, if nobody justifies it, okay, ये violation तो है. So tomorrow Supreme Court can say that do not kill AFSPA, because there was a logic in creating Armed Forces Special Power Act to deal with extreme situations occurring in some specific states. तो इसको हम dead नहीं करेंगे, इसको हम रख लेते हैं. Let's keep it in the law book, but we will not implement AFSPA because actually it is violating the fundamental rights. ऐसे logic लगा सकते हैं हम लोग, ठीक है ना? Supreme Court applied the same logic. Are you getting this or not? Supreme Court applied the same logic in one of the cases, and it said, डॉक्ट्रिन ऑफ एक्लिप्स लग गया. सुप्रीम कोर्ट सेड यार आर्टिकल 13(1) के लिए व्हाई आर यू किलिंग सच अ बिग लॉ, इट मस्ट बी हैविंग सम लॉजिक. सो लेट्स डू वन थिंग, वी रिमूव द पार्ट और वी एक्चुअली inactivate the parts which are fighting with the fundamental right till the time they are fighting with the fundamental right. कल को it can happen. अब आप ये देखो, this article taking away your press was violating which fundamental right? 19(1)(a. कल को ऐसा भी तो हो सकता है, tomorrow it can happen that this right to speech and expression is itself removed from the list of fundamental right. ऐसा हो सकता है कि नहीं हो सकता? Tomorrow you never know that this article itself is removed from fundamental right. Then in that case will this part conflict with your fundamental right? अब तो ये fundamental right है ही नहीं. So tomorrow we can again revive this part of the law. But till the time the conflict between fundamental right and this part is there, we will inactivate this part. Keeping in the law books, we will inactivate part B and C. But part A चलता रहेगा because part A was never in conflict with fundamental right. Understood or not? So this way we saved two parts of our good law. Part B and part C saved, but we are not using it right now. Right now, अभी हम उसको use नहीं करेंगे because it is in violation with fundamental right, and will not use these two parts till the time they are in violation of fundamental right. Tomorrow, by some means, some amendment or some new law, if their fight with fundamental right is gone, then we can again use them as any other law of this country. This philosophy was used by Supreme Court in the famous गोलकनाथनी इन पहले आप 13(1) की लैंग्वेज लिखो, एंड दिस इज माय हम्बल रिक्वेस्ट बिकॉज आई कैन सी मेनी पीपल आर स्टिल थिंकिंग अबाउट इट. राइट द लैंग्वेज एंड रीड व्हाट यू राइटिंग. अकॉर्डिंग टू आर्टिकल 13 क्लॉज 1, समझ के लिखना. Nobody will explain you again this way. Believe me, Article 13 Clause 1 says all the laws enforced in India immediately before the commencement of the Constitution shall be, I'm going slow so that you can read, shall be unconstitutional and void if they violate what? If they violate one or more provisions of Part 3. Part 3 मतलब fundamental rights, comma, to the extent of such violation. To the extent of such violation means that it might happen that the whole law is not contradicting the fundamental right. Some part is violating. तो हम उस part के ऊपर उसको क्या कर देंगे? Unconstitutional and void. It might happen that the whole law is not violating fundamental right. A part of the law is violating fundamental right. So if we apply Article 13(1) on that law, we might invalidate what? That particular part जो कि fundamental right से contradict कर रहा है. ठीक है? This was Article 13 Clause 1. Now Supreme Court, now this case came up in a famous case. कौन सा केस था? बोलो, इसमें नहीं मिलेगा. इसे कहते हैं बीकाजी नारायण केस 1955. इन दिस केस सुप्रीम कोर्ट सेड, सुप्रीम कोर्ट ने अब क्या लगाया? डॉक्ट्रिन ऑफ एक्लिप्स. ध्यान से सुनो, डू नॉट राइट, फोकस हियर. In this case, Supreme Court applied doctrine of eclipse, and it said that let's do one thing. Let's apply doctrine of eclipse in Article 13 Clause 1 also, that If these two laws are contradicting the fundamental right, let's not kill them, let's not remove them from the list of from the constitution itself or from the law books itself. Let's keep them dormant, and tomorrow if somehow the fight between these provisions and the fundamental right is removed, then we will again activate these two laws. But till the time, let them be dormant. इनको मारो मत. Understood? घर में दो अप्रोच होती है ना. When there is suddenly a mouse coming to your house, दो टाइप के लोग होते हैं. Some people run with broom after him, उसके पीछे उसको मारने भागते हैं. Other people, they show him the way out. अरे बाहर निकल जा. Okay, same is this case. Supreme Court did not want to kill the law. Supreme Court said, let's keep it dormant. Let's not kill it. What could be the logic of dormant? Huh? Because if Parliament has made a law, there must have been some logic, some reason behind it. People must have asked for it. वो assume ये करी कि Parliament बहुत जिम्मेदारी से law बनाती है, which is true also. है कि नहीं सर? लिखो. Next line, in Bikaji Narayan case, 1955, in Bikaji Narayan case, 1955, Supreme Court applied, every word is to be read. Supreme Court applied what? क्या apply किया? Principle or doctrine of eclipse. In your notes, they have written this word lapse. वो lapse नहीं है, doctrine of lapse नहीं है, वो doctrine of eclipse है. Correct that, okay? Supreme Court applied the principle of eclipse and said that such a pre-constitutional law, pre-constitutional means which was formed before the commencement of the constitution, such a pre-constitutional law remains dormant. But not dead. And can be revived again, if any amendment to the law removes the clash between that law and fundamental right. So this law मतलब ये law, pre-constitutional law. So this law comes under the shadow of fundamental rights. Very good, sir. Comes under the shadow of fundamental right and remains eclipsed. Or under the shadow till the time the conflict is removed. अब दिस वॉज अबाउट प्री कॉन्स्टिट्यूशनल लॉ. ये तो था प्री. भाई आप ये भी देखो एक चीज, when they made these laws, were they aware that tomorrow in free India there will be something called as fundamental right and these will be the fundamental right? उनको तब तो ये थोड़ी ना पता था. So it was not their fault. But when Britishers or Angrez they were making these laws, or even Indians, because before 1950 we also made some laws. Who made the law? We मतलब Constituent Assembly. ठीक है ना? They actually did not know explicitly that this will be the final form of Indian Constitution and these will be the fundamental rights and it might get in conflict with fundamental right. तब तो उनको ये बात पता नहीं थी. So we can condone their action. Okay, उनको माफ कर सकते हैं. But एक आदमी को हम माफ नहीं कर सकते and we will not condone a particular law. What will be that law, sir? ये भी तो वायलेट कर रहे हैं. I said because these laws, pre-constitutional law, did not have this awareness that we might contradict the fundamental right. They can be given some concession in the form of doctrine of eclipse. They might get some protection. But one kind of law should not be given protection. What is that? Yes. बिल्कुल सही बात है. The laws which were made after the constitution commenced, means if in this day, क्या date है? Whatever. If in this year 2016 you are making a law which violates fundamental right, should you condone this law or should you give protection to this law? No. You had this in mind, you had this knowledge that this law is violating fundamental right and still you made it. So you should not show mercy on this law and it should be axed. यही होना चाहिए ना? होना चाहिए कि नहीं होना चाहिए? So Supreme Court said in Deepchand case that ठीक है, if you want to give protection to pre-constitutional law, give them. मतलब the law which were formed before 26 January. But you should not give protection to post-constitutional laws, and these post-constitutional laws are void ab initio. Ab initio मतलब from the very beginning they were wrong. तो उनको protection मत दो under doctrine of eclipse. Let's not make them dormant. Let's kill them altogether for times to come. उनको law book से हटा ही दो. Because when they were formed on faulty grounds. The law-making body had this knowledge that this might actually contradict with fundamental rights. तो इनके साथ तो मर्सी मत बरतो. This was the stance taken by Supreme Court in Deepchand case. If you do not remember the case, no problem at all. Because in prelims, generally they do not go into this depth and ask you which case, but they might ask you in which case judicial review was declared as the basic part of constitution. वो पूछ सकते हैं. If you remember them, good. But if you do not remember them, no problem. Write down. In Deepchand case, 1959, Supreme Court held मतलब Supreme Court said that doctrine of eclipse can be made applicable only to pre-constitutional laws and post-constitutional laws cannot be revived as they are void ab initio. शुरू से ही ये गलत थे. So they do not get protection under what? Under doctrine of eclipse. Very good. However, in Ambika Mill case, 1974, Supreme Court overruled. Can Supreme Court actually overrule its own decision? Yes. What is the name of that jurisdiction? When it can change its own or it can again go back to its own judgment? और रिवाइजरी jurisdiction भी कह सकते हैं क्या? Write down. In Ambika Mill case 1974, who was the president during emergency? Fakhruddin Ali. बहुत बढ़िया. Means people actually studied at home also. Thank you. Ambika Mill case, Supreme Court overruled its earlier decision and held that doctrine of eclipse can be extended to protect a post-constitutional law also. Supreme Court overruled its decision and said that doctrine of eclipse can be extended to, or can be applied to, or can give protection to a post-constitutional law also. Clear? कोई एम्बिग्यूटी का स्कोप ही नहीं है इसमें. What is Article 13 Clause 1? Any pre-constitutional law, if it is violating fundamental right, will be void. ये 13(1) था. What is Article 13 Clause 2? Post-constitutional law. As simple as that. मतलब the laws as simple as that. 13(1) was for pre-constitutional law before 26 January 1950, and 13(2) will kill a law which is violating fundamental rights, provided that law was made after commencement of the constitution. दोनों चीज वही है, डेट का डिफरेंस है सिर्फ. ठीक है सर? Now see, write down. Give the heading this. Actually, up to this part, no, even up to some part of DPSP, will have little bit of, this kind of intricacies. After some time, when we reach Council of Ministers, this and that, then it will be almost a real ratta. These are intricate things, complicated things. Then we might just get into the factual part. This is more important also, because factually you can, anytime you can read the book and understand. Give the heading this. बताऊंगा यार. See, in this Bikaji Narayan case itself, Supreme Court applied the doctrine of principle, means that case somehow related with a pre-constitutional law only. Bikaji Narayan case आया ही इसलिए था. So if you want to know that in which case it was actually revived, it was in Bikaji Narayan case 1950. Okay, amendability of fundamental rights. This is quite a interesting thing. Can we amend fundamental rights or not? Article 13(2) you write down. Article 13 Clause 2. Article 13 Clause 2. Heading दो, हाँ इसी में दे दो. Says that state shall not make a law. State shall not make a law that takes away or abridges means, yes, to tone down or to beat, or abridges one or more fundamental rights. And if such a law is made by parliament. Now read every word. Every word is made by parliament. It shall be unconstitutional and void to the extent of inconsistency. जितना वायलेट करेगा उतना खत्म हो जाएगा. To the extent of inconsistency. What is Article 15 Clause 4? बोलो सर. अरे उधर से भी बोला करो यार, पढ़ के आया करो थोड़ा सा. Article 15 Clause 4, what is it? Yesterday also I told you. Article 15(4) says that state can make special provisions for the welfare of socially and educationally backward communities. ठीक है ना? And it actually gives rise to something which you call as reservation in different areas or other benefits. ठीक है? 15(4) says reservation. Article 15 is actually against discrimination. By 15(1) क्या कहता है? No discrimination should be made on different grounds like religion, caste, sex, place of birth. ये लिखा है ना? Are they not actually contradictory? By when did we add article? Was it actually from the very beginning? No. First Amendment Act 1951, it brought Article 15 Clause 4. First Amendment Act 1951 brought this Article 15 Clause 4, which says that state can make provisions for the development of socially and educationally backward communities. उनका खास ध्यान रखा जा सकता है. Tell me, is it not a violation of Article 15 Clause 1? What is 15(1)? State shall not discriminate among citizens on the ground of religion, caste, place of birth, sex. ठीक है ना? ये तो contradictory हो गए. And moreover, you see, this was not originally present in the Constitution. It was done later on by Constituent Assembly through First Amendment Act. Don't you think it is liable to be challenged in the court? भाई ये challenge होना चाहिए कि नहीं होना चाहिए? Under which provision? Agar you say that this law somehow appear to be contradictory to the original fundamental right, under which provision you will challenge that in the court of law? ये तो लिखा हुआ है 13 Clause 2 कि ऐसा कोई लॉ नहीं बनना चाहिए जो फंडामेंटल राइट को हर्ट करे, destroy करे. There should not be any law which destroy or hurt the fundamental right. But here it is being done. The fundamental right, we had a fundamental right that all of us will be treated equally, no discrimination will be done. But here it is apparently a discrimination or not. तो ये challenge हो गया in the court of law. And it was challenged that how can you touch fundamental right? Fundamental rights are sacrosanct. You cannot amend. ठीक है ना? Then court said that see, court ने ये जवाब दिया. In which case? अभी बाद में लिखना, जस्ट फोकस हियर. शंकरी प्रसाद केस, दिस थिंग वाज चैलेंज्ड. विच थिंग? फर्स्ट अमेंडमेंट एक्ट. इसको चैलेंज किया गया. उन्होंने बोला that you say that there should not be any law which violates fundamental right, but see, parliament has made a law which is violating the fundamental right. Which fundamental right? 15(1). And who violated? 15(4). Supreme Court was very smart. It should be 51. Shankari Prasad case 1951. Supreme Court was very smart. Supreme Court said that see, this Article 15 Clause 4 has become a reality not because of law. Law अलग चीज है, ये law नहीं था. It was constitutional amendment. और ये दोनों अलग अलग चीजें हैं. Okay, this is just the way you see it. There is no objective reality behind these things. उन्होंने ऐसे रखा इसको. Supreme Court said that Article 13(2) says that state shall not make a law. State ऐसा कानून ना बनाए बट ये कानून थोड़ी ना, इट इज एन अमेंडमेंट इन द कॉन्स्टिट्यूशन. एंड गवर्नमेंट और पार्लियामेंट हैज टू काइंड्स ऑफ पावर. सुप्रीम कोर्ट का आर्ग्यूमेंट था इन विच केस? शंकरी प्रसाद केस 1951. सुप्रीम कोर्ट का आर्ग्यूमेंट ये था दैट पार्लियामेंट हैज गॉट टू काइंड्स ऑफ लॉ मेकिंग पावर. वन इज ordinary legislative power. Ordinary legislative power means the power to make law. Parliament बनाती है ना law. For example, right to information or Food Security Act. ये ordinary law है. Okay. And besides this, Parliament has another power which is ordinary law की power है. And Parliament has got two kinds of law making power. One is ordinary legislative power, other is constitutional legislative power. Law is made by Parliament using this power. Whereas when Parliament amends the Constitution or Parliament touches the law or brings a change in the law, that is being done by the virtue of constitutional legislative power given to Parliament under which article? आर्टिकल 368. और वो बात सच भी है भाई. आर्टिकल 368 क्या है सर? इट इज द अमेंडमेंट टू द कॉन्स्टिट्यूशन. आर्टिकल 368 इज द पावर टू अमेंड द कॉन्स्टिट्यूशन. इज कॉन्स्टिट्यूशन अमेंडेड जस्ट लाइक दैट? इट इज अमेंडेड विद स्पेशल मेजॉरिटी यूजिंग स्पेशल steps and procedures. However, in making a normal law, Parliament might not go into that tough procedure. दोनों अलग अलग चीजें हैं. Understood or not? तो ये this was judgment or this was a reasoning given by Supreme Court that in Shankari Prasad case Supreme Court said Parliament has got two kinds of law making power: ordinary law making power and constitutional legislative powers. And this 15 clause 4, do not write, just focus here. I'll dictate, don't worry. यहाँ समझो सिर्फ. And in 15 clause 4, when Parliament brought this new element in the Constitution, it was done using not the ordinary legislative power but by constitutional legislative power, because to bring this element in the constitution, the constitutional amendment procedures were followed which are quite complicated given under article 368. इसीलिए when an amendment is made in the constitution, do not consider it to be a law, because article 13(2) क्या किसको prevent करता है? Law को prevent करता है fundamental right को violate करने से. This is not an ordinary law, it's an constitutional amendment. So Parliament under power of 368 or the power to amend the constitution can make a change in the constitution even if it hurts a particular existing fundamental right. However, a normal law cannot do so. Parliament cannot ordinarily pass a law in Lok Sabha and along with Rajya Sabha with simple majority that nobody can move out of their home 2 o'clock midnight. वैसे करना भी क्या है, but then Parliament cannot do so because this law will violate your which right? Right to freedom of movement. घूमने की आजादी है ना हमको. ये है. Who is not clear on this? अभी ये इसके बाद वाला है. देखो अभी खत्म थोड़ी ना हुआ है. अनदर केस लिखो इसको. अमेंडेबिलिटी ऑफ फंडामेंटल राइट. 13(2) you wrote na, then write seemingly against. seemingly बोला है मैंने. seemingly means apparently. कुछ लोगों को लगता है ऐसा. seemingly against the spirit of. seemingly against the spirit of 13 clause 2. seemingly against the spirit of article 13 clause 2. The First Amendment Act 1951 amended right with understanding, amended article 15 and introduced article 15 clause 4. I explained that what it is. Article 15 clause 4 It also amended which article? एक दो चेंज और हुए थे regarding fundamental right. What was that, sir? हाँ जी, property in vocation. It also amended Article 19 Clause 6. What is Article 19? Sir बोलो. Article 19 क्या है? Article 19(1) क्या है? 19 Clause 1 is the list of freedoms you enjoy. ठीक है? Next. Amended Article 19 Clause 6 putting reasonable restrictions. जब इसको amend किया तो उससे क्या किया? Putting reasonable restrictions on right to occupation. Restrictions on right to occupation. It also brought, it means First Amendment Act. It also brought which schedule? Anyone? बहुत बढ़िया sir. It also brought 9th schedule to the Constitution. What is 9th schedule? Anyone? Can I rub this? मिटा दूं इसको? Have you noted down this? First Amendment Act, Parliament made a law that this is 9th schedule. इधर ध्यान दो. That this is 9th schedule. And tomorrow when we make a law, कल हम एक नया law बनाएंगे. And if we put that law in this list, schedule का एक list है ना, in this list, then Supreme Court cannot go or review that law. तब आप Supreme Court में जाके ये नहीं बोल सकते sir, this law violates my fundamental right. Why? Because this law has been added into 9th schedule. The laws which are added in the 9th schedule according to the First Amendment Act were to get protection from judicial review. एक बार law इसमें डल गया तो judiciary उसको ये नहीं बोल सकती कि no this is violation of constitution because judiciary cannot review it. Judiciary फिर उसको पढ़ नहीं सकती और उस पर अपनी judgment नहीं दे सकती. Okay, now article 9th schedule, it actually took which power? Judicial review. It is preventing judiciary from reviewing an act which is mentioned in 9th schedule. भाई land reform लाना था basically नेहरू जी को. Pandit Nehru wanted to bring land reform, but when I want to bring land reform, will I not violate the fundamental rights of जमींदार? भाई उनकी जमीन छीन रहा हूँ, right to property तो जाहिर ही ना उनकी. It will certainly violate the right of property to these zamindars. And I expected that they will challenge it in the court of law. वो challenge तो करेंगे जमींदार. सर हमारा प्रॉपर्टी छीन ली गवर्नमेंट ने. तो गवर्नमेंट ने क्या किया? दे beforehand they made this 9th schedule. एक उन्होंने प्रोविजन तैयार किया that when we will make this law to bring land reforms and other laws, then we will put that in 9th schedule so that judiciary will not be in a position to review it. चलेगा फिर अपना भी काम. But then judiciary was again very smart. Write down 9th schedule, which introduced 9th schedule to constitution, which took away the power of judicial review, of court. Paragraph change. However, this First Amendment Act, the First Amendment Act got challenged before the Supreme Court. In शंकरी प्रसाद, शंकरी है ये, शंकर नहीं है, शंकरी प्रसाद केस 1951. Why was it challenged, sir? First Amendment Act challenge क्यों हुआ? It was violating fundamental right 15 है कि नहीं है? And 19 also. राइट टू ऑक्यूपेशन पे रेस्ट्रिक्शन लगाई थी उन्होंने, ठीक है ना. बट द रूलिंग केम but the ruling came, challenge तो कर दिया आपने First Amendment Act को, the First Amendment Act got challenged also, but the ruling in this case by Supreme Court came in the favor of Parliament. उन्होंने बोला भैया Parliament ने जो किया ठीक किया, because Parliament, write down, but the ruling came in the favor of power of Parliament. Keep reading what you are writing, sir. Ruling came in the favor of power of Parliament to amend the Constitution under Article 368. Supreme Court said that Parliament enjoys two types of legislative powers: ordinary legislative power and constitutional legislative power. Constitutional legislative power will not fall in the ambit of, will not fall in the ambit of law, L-A-W, law, double underline. This word has a meaning. Achha, ordinance will, you know what is ordinance? Will not fall in the ambit of law as mentioned in Constitutional Amendment को हम law नहीं बोलेंगे इसमें, वो वाला law नहीं बोलेंगे, as mentioned in Article 13 clause 2, write down, 2, as mentioned in Article 13 clause 2. 13.3 is defining it, okay, as mentioned in Article 13 clause 2. Therefore, court upheld the constitutional validity, court upheld the validity of First Amendment Act. Paragraph change. However, please keep reading, समझ के लिखना. However, the court said any enactment of Parliament made in exercise of ordinary legislative power will be called law. Which comes under the scope of clause 2 and would be void, VOID, and would be void if it violates fundamental right. Conclusion ये है, therefore in Shankari Prasad case, लिखो, therefore in Shankari Prasad case, court held that Parliament can amend any part of Constitution including fundamental rights also. Yes or no? Yes, बहुत बढ़िया. Including fundamental rights. ठीक है सर. Parliament can amend any part of the Constitution including fundamental rights. Now, if under First Amendment Act Parliament has touched fundamental right or even has reduced the power of fundamental right under Article 19(6), no problem with that. they are having that power, they use that power under article 368. उसी को यूज करके तो अमेंड किया उन्होंने कॉन्स्टिट्यूशन को, ठीक है ना. Now see, now people also have different arguments. Now this case again got challenged. In which case? पहला था शंकरी प्रसाद केस, then गोरखपुर नहीं है यार, ये गोलकनाथ है. ओके, गोलकनाथ केस 1967. अब फिर से चैलेंज हुआ ये. And in this case, Supreme Court gave a very beautiful argument. You will also appreciate that and like that. ठीक है? See this. Supreme Court in this case said agreed with what court said in Shankari Prasad case. जो उन्होंने बोला हम मानते हैं उस बात को. But एक बात बताओ. Tell me one thing. Supreme Court said this. Tell me one thing. Tell us one thing. Where in article by Supreme Court amended the constitution and fundamental right using which power? Article 368. अब Supreme Court ने पूछा, but where in article 368 it is written that law parliament is having the power to amend the law or to amend the constitution? Because article 368 is only giving the procedure to amend the constitution. भाई इनिशियली इन दिस, ये अजीब सी बात नहीं है. Is it not very strange? Supreme Court said Article 368 only explains you the procedure by which you change the constitution, where it is saying that parliament can actually use the procedure. अभी अजीब सी बात नहीं है. I give you food, a platter of something, बहुत बढ़िया खाना सजा के आपके हाथ में दे दिया. And when he started eating, I asked him, why did you eat? Now, is it not very strange? On first instance, why should I actually give him this plate? It is expected that he will use it. तभी तो दिया उनके हाथ में. The same logic was applied here in this Golaknath case. Supreme Court said, Parliament amended the constitution under Article 368. ठीक है. But actually, Parliament never had this power to amend the constitution under Article 368 because Article 368 only explains the procedure to amend the constitution. पावर तो दी नहीं उन्होंने. ये लीगैलिटी की, सी दिस इज द ब्यूटी ऑफ लॉ. द पीपल हु डू लॉ और दे ड्राफ्ट द कॉन्स्टिट्यूशन और लॉ, दे आर वेरी केयरफुल अबाउट एवरी कॉमा और अबाउट एवरी फुल स्टॉप, बिकॉज एवरी कॉमा और फुल स्टॉप कैन हैव अ मीनिंग. पंक्चुएशंस की भी वैल्यू है उसके अंदर. It is said in one of the, I mean, I don't know actually this is true or not. Somebody said that Motilal Nehru was a very prominent lawyer of his times. He was fighting a death case, death penalty case. The judge gave the death penalty to one particular person. Okay, he must be hanged. ये लिख दिया जज साहब ने. Motilal Nehru already very hurt because of this issue that he lost the case. He also went when this person was to be executed. Now, when he was just released, अब एकदम से तो प्राण निकल नहीं जाएंगे ना. He will not die instantly. When he was released, he said, "Okay, pull him back instantly." He shouted, and it is said that he was pulled back. The person said, "Why? Why did you stop his execution?" He said, the judge only said he must be hanged." तो आपने टांग दिया उसको, अब लो वापस. Understood or not? भाई hang तो हो गया, मारने के लिए थोड़ी ना बोला जज साहब ने. And from then it was said that the judges used to write, he must be hanged till death. तब तक लटकाओ जब तक मरे नहीं. ठीक है? This is the way law is interpreted by these people. So Supreme Court in this case interpreted the same logic. उन्होंने बोला Article 368 तो बोलता है procedure ये है, but it nowhere says that you have to use the procedure. Is it not strange? तो उन्होंने बोला नहीं, since you don't have the power to amend the constitution under Article 368, you cannot amend constitution and particularly fundamental rights. समझ आई ये बात या नहीं? Right now. You write that, and if you write that, and whatever will remain in your mind when you reach home, using that reminiscence memory, read these notes again and today itself. I do not take guarantee for tomorrow. अगर आज ही पढ़ लिया, you will understand them and you will remember them for future. Otherwise, let me tell you, amendability of fundamental rights and doctrine of eclipse and all these things, this can create problem, and it creates problem for some people. ठीक है सर, आज ही पढ़ना है इसको. Write down. However, in Golaknath case 1967, Supreme Court overruled its earlier decision, and Supreme Court overruled its earlier decision and said and held that Article 368 contains only the procedure to amend the Constitution. And did not confer the power to the Parliament to use this procedure. That is, amend the Constitution. Therefore, Parliament has only one type of legislative power, which is excellent, which is ordinary legislative power. बहुत बढ़िया. Using that, Parliament cannot amend the fundamental rights. क्योंकि वो कॉन्स्टिट्यूशन ही अमेंड नहीं कर सकते. ठीक है सर, यहां नया पंगा खड़ा हो गया कि कॉन्स्टिट्यूशन ही अमेंड नहीं करना है, because nowhere they give you the power. So what do you see? Did I not tell you when I was taking the first class that it can happen that sometime Parliament and judiciary might come into a kind of a debate or tug of war, where judiciary does something, Parliament negates that. Judiciary will again do something, Parliament will again negate that. ठीक है ना? Here, judiciary took away the power of constitutional amendment from legislature. So Parliament did what? Parliament amended the Constitution again using this power. Parliament again amended the Constitution. 24th Amendment Act 1971. भाई वैसे तो ये करना नहीं चाहिए था उनको, because they had no power under Article 368, but they did. उन्होंने देखा इस बार ट्राई करके देखते हैं, जज बदल गया, क्या पता जजमेंट बदल जाए, which actually happened. बदल गया ना सर, 4 years. तो 24 पार्लियामेंट ने क्या किया? 67 सुप्रीम कोर्ट said you cannot amend the constitution. So because why could not you amend the constitution? Because Article 368 is only having the procedure to amend the constitution. It is not giving you the power. So what parliament did? Parliament changed the language of Article 368. चलो यही चाहिए ना, लिख दिया. Parliament changed the language of Article 368 using 24th Amendment Act 1971, and now on, since then, Article 368 says the procedure to amend the constitution and power to amend the constitution is so and so. अब explicitly लिख दिया उन्होंने, ठीक है ना? Understood sir? Right down. So the Parliament responded by enacting 24th Amendment Act 1971, which amended the title 24th Amendment Act 1971 written on board, which amended the title of Article 368 which now reads अब उसको ऐसे देखते हैं, which now reads quote unquote the procedure to amend the constitution. You can use short forms also. For constitution you can write C, the procedure to amend the constitution and power to amend the constitution. अब what will happen? Parliament ने अपनी बाजी मार ली. Parliament took upper hand and they added a new word in Article 368. अब क्या होगा? Of course review. somebody filed a petition against 24th Amendment Act. उन्होंने बोला ये गलत है, पार्लियामेंट के पास तो पावर थी नहीं, how did they amend the constitution in the first place? Okay, somebody filed a petition, and thankfully this was a new bench in the famous case in Keshwanand Bharti case. Somebody challenged this 24th Amendment Act 1971, whereby the language of Article 368 was changed. Okay, this time Keshwanand Bharti case, the bench, a big bench, they said what Parliament did by amending the constitution is okay, it is legal, because even if it did not have the word originally, the power to amend the constitution, Parliament had this power to amend the constitution, because otherwise constitution cannot become evolving, cannot become organismic, वो तो वहीं रह जाएगा, which was formed by Constituent Assembly. But unless Parliament has this power to amend the constitution, how can you expect Constitution of India to run shoulder to shoulder with the changing times and values? It will become stagnant. So the changes in the constitution which were brought by the Parliament before that and now under 24th Amendment Act 1971 are okay, and they had this power. They can amend the constitution, and they can amend any part of the constitution, including fundamental rights. However, while amending the provisions of constitution, Parliament must ensure that they should not touch or they should not fiddle with the basic structure of the constitution. अगर वो सलामत है, if the basic structure of the constitution is intact, Parliament can do anything with the constitution. They can amend any part of the constitution, including fundamental rights. Understood, sir? Write down. In Keshwanand Bharti case 1973, in Keshwanand Bharti case 1973, the 24th Amendment Act 24AA, among other things, were challenged. Among other things, were challenged before Supreme Court, and the court upheld the validity of court upheld the validity of 24th Amendment Act and said that Parliament, by the virtue of its powers, Parliament by the virtue means because of Parliament by the virtues of its powers under Article 368 can amend any part of the constitution, including fundamental rights, provided it does not destroy the basic structure of the constitution. Supreme Court did not. ऐसे लिखो, basic structures are those parts or features. Basic structures are those parts or features of constitution without which the constitution loses its basic character. Supreme Court did not define exhaustively what all, did not define exhaustively means completely what all features are part of basic structure but in various judgments we keep knowing them. Example, any example of basic structure? Judicial review, secularism, sovereignty, separation of power, आगे fundamental rights. ओके एक दो लिख लो आप लोग, आपको फायदा रहेगा इससे. Sovereignty of India, judicial review, और एक you are missing one very critical part of basic structure, एक बहुत important है but then you are missing it, federalism. Very good, federalism also. Mandate to build a welfare state, ये भी part of basic structure है. Mandate to build means aim, mandate to build a welfare state. ठीक है सर, clear? If I have to categorize all the fundamental rights in different categories, what are those categories? 6 or 7? 6 or 7? 6. First category, article, then article. वेरी गुड सर, ये रट्टा चाहिए. Then right to constitutional remedy means if you have not received what constitutional promised you, you can have a remedy for that. You can go to court. ठीक है ना? We'll discuss each of them one by one. Let me tell you, there are number of fundamental rights. Sub clauses भी हैं. You are not supposed to read each and every sub clause. Article 13(1), 13(2) was required. 13(3) will have the definition of law. कि भाई अगर हम law word use करें तो what is the meaning of law? Law is ordinance a law or not? Is by law or not? ठीक है ना? You may not actually require these things for civil services prelims. Judicial के लिए ठीक है. So what I mean to that is do not bother yourself beyond a limit. Whatever article I am dealing with, they should suffice. बाकी अगर किस्मत ही मेहरबान हो तो कुछ कर नहीं सकते, but then this will suffice. ठीक है? I'll take the articles which are required and most important also. Article 14, right to equality. write the language and then I'll tell you what is the meaning of it, because it requires some elaboration. Write down. Article 14, right to equality, states that, means what is right to equality? It states that state shall not deny. देखो not आ गया ना. I explained that few articles are in negative injunctions form. State shall not deny to any person any person. You know what is the significance of this word any person? This right, foreigners will get this right. Yes, I use the word any person. I did not use the word citizen. Few rights are exclusively available to citizens, few are to everyone, provided they are not enemy aliens. Enemy aliens means they are not coming from a country, foreign country, which is an enemy country. उनको हम ये right उनको भी नहीं देंगे. ठीक है ना? Right to equality will be given to citizens as well as to foreigners, provided those foreigners are not from an enemy country. For example, we have attacked China. ठीक, मतलब चाइना ने अटैक नहीं किया, हमने किया है. Then in that case we can say that their citizens are enemy aliens and we will not give this kind of right to them. ठीक है sir? Write down. State shall not deny to any individual or any person the right to ये दो चीजें. State shall not deny to any individual the right to equality before law and equal protection of law. दोनों अलग चीजें हैं. One is something, one is other thing. What is the meaning of equality before law? इसका मतलब क्या सर? What is the meaning that state cannot deny you equality before law? All people are equal in front of law and nobody is. I gave you one example for parents. All kids are equal or not? सब बराबर है. Will they have preference for this particular child or that particular child? For example, if he is getting 90% marks, will he become favorite of the parents? No. Yes, no. ठीक है? Favorite नहीं होगा. For them, everybody is equal and nobody will have a special privilege. Law के केस में भी यही है. Law is kind of parent only. Law. Whether it is Mr. Ambani, whether it is this Khan, that Khan, Akshay Kumar or whatever, or whether it is Teesta se Talwar, everybody will be treated equally. They will be applied with same law and they will be tried in the same court. Law will not see them in a different form, irrespective of their economic and social status. For law, every person, even if he is not a citizen, will be equal. अब Italian Marines को ले लो. When we caught the Italian Marines, did we try them in a separate court? उनके लिए अलग से court बनाया था? No. We were trying them in the same court and the same law also, which were available in India. They applied on them. If tomorrow there is a case of Mr. Ambani, then you again will call him in the same court. वो थोड़ा बोलेंगे no, please make a separate court for me. No. And even a beggar who has committed a crime, he will also appear next to him in the same court. This is the beauty of Indian Constitution. It provides equality before law. In the eyes of law, everybody is alike and nobody, ये important है. There will be no special privilege given to any individual by law. Law किसी को special privilege नहीं देगा. Same law, if you have been called by the court to appear in person and you are denying, you are not coming again and again, court can issue summon against you, no matter how much rich you are, no matter what you are. ये है equality before the law. Okay, however exceptions भी हैं इसके अंदर. Write 2 lines on it. From which country we have taken this? It can become Britain. UK से लिया है हमने इसको, Britain. आप एक बात बताओ, tell me, if I ask you, do you smell a negative wording in this particular thing or positive wording? हाँ जी, किस चीज की खुशबू आ रही है आपको इसमें, नेगेटिव और पॉजिटिव? What is the wording or orientation? नेगेटिव आ रही है, पॉजिटिव. Why positive? ठीक है, तो इट इज काइंड ऑफ नेगेटिव वर्डिंग. किसी को अहमियत नहीं मिलेगी. दिस इज द कोर ऑफ दिस थिंग. Nobody will have special privilege in the eyes of law. Okay, this is the core of equality before law. Nobody will have special treatment, special privilege in the eyes of law. Means it is negatively worded. Okay, write down. Equality before law, the concept originated in England. Comma, a negative concept. Negative means not negative in intention, in wording. Negatively worded concept, you can say. It means absence of privileges enjoyed by particular individual in the eyes of law. कानून की नजरों में किसी को अहमियत नहीं मिलेगी. In the eyes of law, that is all persons, irrespective of, all persons irrespective of their rank or position are equal before the law. And shall be treated equally. सबको बराबर ट्रीटमेंट दो. Shall be treated equally. By whom? Law. By law. It means jurisdictory equality. Jurisdictory equality and not complete equality. That is, all persons are subject to ordinary jurisdiction of court. Ordinary jurisdiction of court means whatever procedure is laid, it will apply on them. No special procedure will be formed for anybody. Ordinary jurisdiction of court, and they can sue. They can sue or be sued. They can sue. या तो वो किसी और के ऊपर क्लेम कर सकते हैं या कोई और उन पे क्लेम कर सकता है. Either they can put a claim on somebody or somebody else can put a claim on them. They can sue or get sued in ordinary court of law. You know why I'm using this word ordinary again. Ordinary मतलब Supreme Court, High Court or whatever court. In France, what used to happen, if you were, France में पहले ऐसे होता था, if you were a member of administration, then there would be separate laws for them. Administrative laws बोलते थे उनको. If you were the member of administration, then there would be separate laws which will apply on you and not on others. And there will be separate court where you will be tried. Understood or not? This used to happen in France. Okay. Now see, exceptions are the beauty of our constitution. So equality before law will also have some exceptions. मीन्स इक्वलिटी बिफोर लॉ क्या कहता है? व्हाट इज द एसेंस ऑफ इक्वलिटी बिफोर लॉ? Do not say that everybody is equal. You say no special privilege. No special privilege will be given to any one person. Same law will apply on everybody. Same court will be there for everyone. ठीक है ना? However, there are some exceptions. Can you tell me exception? कोई भी? बिल्कुल. Member of parliaments. Members of parliament. They have some privileges. I'll tell you. उनको कुछ छूट है. ठीक है ना? For example, when parliamentary session is going on, they cannot be called as a witness in a particular proceedings. However, this will not apply on you. यहाँ उनको छूट मिली कि नहीं मिली? But then you could have said one more thing. Armed forces तो हैं ही. Then you could have said president and governor. They enjoy huge privileges which are not available to anyone. ठीक है ना? जैसे कि इस सर अगर आपने मर्डर किया होता वैसे विल यू बी स्पेयर्ड? नो. बच से थोड़ी ना यार, तब केस चलता आपके ऊपर. बट देन इफ प्रेसिडेंट ऑफ इंडिया और गवर्नर ऑफ अ पर्टिकुलर स्टेट दे कमिट सच क्राइम, भगवान ना करे ऐसा हो, बट देन सपोज दे कमिट, विल दे बी स्पेयर्ड? उनको छोड़ देंगे हम लोग? They will be spared till the time they are president or governor. समझ रहे हो आप? तो हम क्या करेंगे? Impeachment. First we'll take out that immunity of this office, president and governor. पहले उनसे प्रेसिडेंटशिप ले ली जाएगी और फिर उन पे केस चलाएंगे. Understood? So you want to settle a score and you become the president, you can do whatever you feel like, but ensure impeachment is avoided. ठीक है ना? Because the day impeachment takes place and now you are no more a president, you will be again tried in the same court, same rules, and you will go to the same Tihar jail. वहाँ पे खाना भी normally मिलेगा. Okay, you enjoy this immunity till the time you are president or governor. Understood? Write down. However, few exceptions are there. However, few exceptions are there to equality before law. Few exceptions are there to equality before law. For example, few exceptions are there to equality before law. For example, president and governor. अच्छा ये बताओ, are they answerable to court of law for their functions? चलो लिख लो, आपके बहने पे लिख देता. President and governor are not answerable to a court of law for discharge of their official function. Remember, only official function. For discharge of their official function. Second privilege or second exception, no criminal proceedings whatsoever, किसी भी तरह की, no criminal proceedings whatsoever can be initiated or can be started against president or governor. Third, can we start a civil case against the president or governor? Yes, civil case चला सकते हैं इनके ऊपर 14 days और ज्यादा 2 months notice. For example, wife put a claim or she filed a divorce asking for alimony, तो civil case हो जाएगा ना सर. But for that we need to have 2 months of notice, right? ऐसे नहीं कि अचानक से सर आपके ऊपर केस आ गया. You might be meeting a foreign dignitary, shaking hand with him, and वहाँ पे LED पे आ रहा है. Civil case has started against the president. He must know in advance when you are going to start a case against him. 2 महीने का notice देना पड़ेगा सर उनको. Okay, write down. No civil proceedings in the case where relief is sought. No civil proceedings in a case where relief is sought matlab demanded, where relief is claimed, can be initiated against them except before expiry of two months of notice. Will anybody tell me what is the meaning of rule of law? अगर हम do we अच्छा ये बताओ सर आप बताओ, do we have rule of law in India? Yes. What is the meaning of rule of law? Very good. Law is supreme and nobody is above law. Whether it is the president of India or it is the biggest industrialist living in India, nobody is above law. Law matlab lex, rex, rex matlab king. Rani bhi ho sakti hai, no problem, but then here we'll write king. Lex, rex, lex matlab law. If the law is king in a place, in a society, in a country, अगर law राजा है, उससे ऊपर कोई नहीं है, if nobody is above law, then it means rule of law is prevailing. Whether it is the prime minister or president or whatever, if they are working as per the law, they are working under the law, it means rule of law is prevalent. Rex lex पहले होता था, king used to be the law. ठीक है, write down this rule of law. From where we got this concept of rule of law? Who gave the concept? Dicey. Dicey किसी का नाम है, it's not the word Dicey. A. Dicey. Rule of law, the concept came from England. This was given by this person Dicey. Has been incorporated or made part, मतलब incorporated मतलब made part of right to equality. Sir, you see this thing. If I am a poor man, Ambani is a rich man, you know this thing, no problem in that. Economic status gap huge, but then when it comes to dealing with the law, will we be dealt differently? No. Law will equally apply on me as well as on him. Both of us will be tried in the same court. Means who is having the prevalence? Ambani? No. Law is having the prevalence. Uski chal rahi hai. Means if you want to have actual equality in a country, first what you want to bring? Rule of law. Because unless law is prevailing, somebody will might take an upper hand over somebody else. Law ही तो है जो सबको बराबर कर देता है. Who is stopping Mr. Ambani to acting not against you arbitrarily? कौन रोकता है उनको? Law. You remove the law, he might become the king himself. है कि नहीं है? Since law is prevailing and law is having an upper hand and the final word, everybody claim to be equal. जिस दिन ये law हट गया, then you see the person who is economically powerful, he'll exploit you, and nowhere you will get a feeling that I am equal to him. फिर वो जो बोलेगा वो कानून बन जाएगा. Thankfully, this is not the case in India at least. Here, all are equal because ultimately it is not somebody who is economically powerful whose will is prevailing. It is the law who is prevailing, which is making everybody feel alike. Write down. Rule of law means law is supreme. That is lex. Supremus. Lex supremus means law is supreme. I gave you this word because you never know, they might ask you what is the feature of rule of law, और वहाँ वो lex supremus लिख देंगे. Though it generally never happens, but then still it can happen. You never know. So लिख लो, कोई दिक्कत नहीं. That is, law is supreme and absolute supremacy of the law as against the arbitrary powers only adoption of rule of law has changed the concept of rex मतलब king और lex मतलब law. पहले ये था, earlier this was the case, rex lex, king was the law, but then this concept has now been changed to lex rex. अब law है king. And who brought the transformation, sir? Rule of law. Write down. Changed the concept of administration from rex lex to lex rex. Which is very much essential for stability of India. क्योंकि law की नहीं चलेगी तो chaos हो जाएगा. Constitution under article write with understanding, do not just mechanically write. समझ के लिखना. Constitution under Article 32 and 226 empowers the Supreme Court and High Courts to enforce this rule of law against executive and legislature. ROL means rule of law. ROL is part of basic structure. If you say rule of law prevails, three things should exist. तीन चीजें होनी चाहिए अगर आप कहते हो rule of law है यहाँ पर. ठीक है? हाँ जी, बताओ. पहली बात, no, what you are saying is correct and this is out of your common sense learning. वो सही भी है. But then this is a technical answer which only people who are actually lawyer or even may not be a lawyer, they have read it somewhere, they can answer it. कि अगर rule of law है, what is the meaning of rule of law of India? Three features have to be there. Absence of arbitrary powers. Arbitrary का मतलब क्या है? Arbitrary means having no logic. Somebody, now if I punish him for no reason, am I not arbitrary? If you have rule of law, nobody should be punished without any reason, and that reason should have been established in where? Court of law. Do not write, I'll dictate this. No man shall be punished without a violation of constitution or violation of law committed by him, and that violation should have been established where? Court of law. ये साबित भी होना चाहिए कि उसने ये काम किया है. It should not happen that you feel, no, I am inspector, I feel that he has violated law. No, you should prove that also. If that is happening, there is rule of law. And if this is not happening, you are punishing people for no reason, even without you have proved that they have violated the law, and it means rule of law nahi hai. Tell me to which thing you can relate this idea to. Means when you write an answer in examination, because these things come in newspaper again and again, so I'm asking you this, किस चीज से इसको जोड़ सकते हो? Supreme Court observed that they, particularly in Bihar, this was a case, that there are 70% under trials. They are not even under trials, they are prisoners. They are in jail and they are not even knowing why for they are in jail, and people who know that they are in jail for this reason, never before they have encountered the magistrate for 6 years or 7 years they have been into jail. Getting me or not? There are so many people, so many prisoners we have who have not seen even the magistrate once. Means they are suffering for no reason, and their crime, even if they have committed, has not been proved. Getting me or not? There are so many people who are in jail who are suffering for no proved reason. And when this is happening at a large scale, see, 1 or 2 cases can happen, and if it is happening at a large scale, mass scale, means this is hurting what? Rule of law. Some time back there was a provision which was mooted that let's release the prisoners who have completed this much of years in jail, because they are only under trials. Why should they suffer? If I am an under trial, for example, मेरे ऊपर एक charge है, I am under trial, and I am in jail for 10 years, and later on it was found that actually I was innocent. Who will compensate those 10 years of my life? So we want changes in certain areas of criminal law. क्योंकि अगर ऐसा हो रहा है तो this is a violation of rule of law or not? This is the case right now. Rule of law has 3 principles. First, no man can be punished. No man can be punished. Men, women both, but then I just wrote men. No man can be punished or made to suffer. No man can be punished or made to suffer except for violation of law. Except for violation of law, and such violation should have been established. Except for violation of law, and such violation should have been established in an ordinary court of law. Ordinary court of law. Sir, second feature क्या है इसका? What is the second feature? All persons should be tried in the same court. Write down. All persons are subject to ordinary law of land. उनके लिए अलग से कोर्ट नहीं बनाएंगे हम लोग, as we used to do in France. If you were member of administration, you had a different court in France, and different laws applied on them. तभी तो some people felt that in France there was no rule of law. ठीक है ना? Write down. Second, all persons are subject to ordinary law of land without any distinction. That is, all can sue. Sue means putting claim on somebody. That is, all can sue and get sued. SUED. Before the same court. Before a court, not same court. We have taken both the provisions from England. We took the third also, but we modified it accordingly. Okay. Third provision क्या कहता था? In India, it says that every law should be in line with Constitution. You should not make a law which is against Constitution. This is in India. Third provision of rule of law says that every law which is made in India should be in consonance with Constitution. no law should violate constitution, or every law should have been driven from the power given in the constitution. If the constitution gives the power to him that you make the law, only then he should make the law, otherwise not. ठीक है ना? Every law should have emanated from constitution. ये हमने यहाँ बनाया. Why do you think that this was not taken from Britain, or actually we modified this third provision? Yes, because in Britain, first of all, you have no written constitution, and even in unwritten constitution, there is the parliament which is supreme. Whatever parliament will say will become constitution. But यहाँ पे supreme कौन है? Constitution. Write down. Third principle as applied in India is a modification of British concept of rule of law. It says, third principle says, all the laws passed by the legislature must be consistent with the provisions of Constitution. Is there any exception to rule of law? कोई एक्सेप्शन है? कोई बचा है जिसपे रूल ऑफ लॉ अप्लाई नहीं होता? किस पे सर? सिक्योरिटी पर्संस, अभी आपको एग्जांपल दिया था मैंने, प्रेसिडेंट एंड गवर्नर, दे आर द एक्सेप्शन. इवन मेंबर ऑफ पार्लियामेंट्स, दे हैव व्हाट? प्रिविलेजेस which saves them from application of certain law in extraordinary situations. Done. What were we doing till now? Sir, अभी तक क्या चल रहा था? Under which heading? Equality before law. Equality before law was the first part of the right of equality. भाई right of equality के दो part थे ना? Right of equality two parts. Equality before law. What was the other part? Equal protection of law. Equal protection of law, very interesting and very easy concept. Tell me, from which constitution we brought this concept? अमेरिका से लाए हैं. Everything imported in Indian constitution. ठीक है? Imported ज़्यादा better होती है ना सर? We give more value to imported सामान. सीधा अमेरिका से. Equal protection of law. हाँ सर बताओ. What is the meaning of equal protection of law? इसका मतलब क्या है? बोलो सर, आप बताओ. अरे बोलो, कुछ भी बोलो. बोलो. Everyone is protected by same law. मतलब same law will apply on all. But then this was first part only.
All the people will be under trial. They'll have the same kind of.
बोलो. What is the meaning? बोलो sir.
The law must be equal among the equal. That is, like should be treated alike.
But then who are equal? Question is this. You have listened that Amitabh Bachchan song, बड़ा famous song है, which he sang himself. ईर बीर फत्ते सुना है आपने? अरे very famous song. कोई बात नहीं. A, B, C. तीन बच्चे हैं A, B, C. Same age, same class, triplet थे. A, he secures 95% marks in examination. इसके 95% आते हैं. B, 90% marks. C, saves himself from failing every time. 40% marks pass होता है. Who is a fool? For parents, who is actually a fool among the three? कोई नहीं. Thankfully, you did not say C. C के सबसे कम नंबर आते हैं. He appears to be a fool for you, but for parents, all are equal. But then C, the treatment will not be equal. इसकी क्या होगी? Extra care होगी इसकी. Because he is C. He's the weakest link. सबसे ज़्यादा कमजोर ही है. For parents, if you see, if there are 3 kids or 4 kids, whosoever is actually the weakest, mentally, physically, or spiritually, whatever, parents will, they will love all 3 equally. वो पहले वाला concept, equality before law. They will love all 3 equally. However, they will first make them equal. ये तीनों को पहले बराबर भी तो बनाएंगे. And how will they make all? Are they equal right now? No. As per the objective assessment, they are not equal. He is actually lacking on intellectual front. इसको जरूरत है support की. So parents will actually first make all the kids equal, and to make them equal, इससे क्या करेंगे? He will be sent to a special treatment or special education system. For example, if he cannot understand the conventional style of teaching, he might be sent into a different style where he might be shown some pictures or some experimentation through which he can understand what he is doing. अब हम maths करते थे. Did you ever understand that why we were actually carrying out differentiation or integration? कभी समझ में आया? But we just what we did, we mucked the procedure. Integration से पहले ये करते हैं, फिर ये करते हैं, फिर ये करते हैं, रट्टा. But why actually we are doing integration? ये समझ में आया कभी नहीं. For this child, we will send him to a special kind of education system whereby he can boost himself up and he can reach his potential. The problem is not with the child. The problem is with the environment in which he is into right now. सबका nature अपना अलग-अलग है. He is requiring a different kind of protection or help from parents. The day he become equal, अभी तो हम इसको बोलते हैं, ये बोलते हैं, I just want this, ये खाने का मन हो रहा है. पेरेंट बोलते हैं ठीक है तू खा और पढ़. They will give him extra benefit. But the day he also starts getting 90%, ये खाना पीना सब बंद हो जाएगा, because now they have become equal. अब बराबर हो गए. Now he might not be given extra benefit by parents or special care which he was getting till now or till the time he was weak. Right or wrong? The same thing is equal protection of law. Law will protect everybody equally, provided they should be equal. All 3 will get same treatment provided they are equal. But till the time they are not equal, somebody will be given extra care, extra benefit, and that extra benefit is not discrimination. That is protective discrimination. If we are sending him to extra classes, we are providing him some extra facilities. Whatever he is asking to remain happy and study, we are giving him so that he becomes equal to them. And the day he becomes equal, अब हम तीनों को बराबर treat करेंगे. Reservation is this thing or not? If this is the depressed caste, is not state extending extra benefit to this caste? But are these benefits discrimination against them? No. The purpose of this benefit is to strengthen this particular community. the day, ये भी याद रखना, it's not the end, the day this community comes at the level of other two communities which are advanced socially and educationally, the day this community comes at the level of these two communities, these special benefits which are coming on this community will stop. क्योंकि तब वो बराबर हो जाएंगे ना. Equal protection of law is a principle which says law should treat everybody alike provided they are alike, and if everybody is not alike, you give some extra benefit to somebody who requires that and bring them at equal platform. If we give some extra concession to women, then it is not so because she is a woman. We give because she is not getting the required social environment to come forward and compete with men at equal level. UPSC has waived off the fee of women or not? 100-200 रुपए की जो फीस लगती है वो उनको नहीं लगानी पड़ती. Two-fold benefit. First, you save money. Second, no complication. Because sometimes men they forget to pay the fees और form reject हो गया आ जाता है. यहाँ वो झंझट ही नहीं है. Women, we give this concession because we know, state knows that in India everybody is not ready to spend money on girl child. So अगर even sometime for you 100 rupees 20 rupees may not matter at all, but for somebody it might matter. Parents may not spend even 100 rupees उनके ऊपर, but then they might be bright. So for this case, if they are having this facility, it is to strengthen them so that they come at equal level, and the day they come at equal level, तब बंद हो जाएंगे ये extra benefits. ठीक है ना? Right now. Tomorrow the geography class starts at 1:30 p.m. रोज 2 बजे होती है ना? Tomorrow 1:30. Okay, right now. Equal protection of law concept from America, US. A positive concept that is like, L-I-K-E, like should be treated alike. It does not mean uniform application. Does not mean यूनिफॉर्म एप्लीकेशन ऑफ लॉ. इक्वालिटी का मतलब ये नहीं है एक ही लॉ सब पे लगा दो. यूनिफॉर्म एप्लीकेशन ऑफ लॉ अंडर ऑल सर्कमस्टांसेस. बट सिचुएशनल वेरिएशंस, सबकी सिचुएशन अलग है, बट सिचुएशनल वेरिएशंस आर टेकन इनटू अकाउंट before applying the law. Before applying the law. That is equality of treatment. That is equality of treatment. Equality of treatment in equal circumstances. It provides for positive discrimination. It provides for positive discrimination or protective discrimination, under which protective discrimination or positive discrimination under which reservation policy is justified. Article 14 does guarantee equality among equals. इक्वालिटी तो होनी चाहिए, बट पहले सबको बराबर तो बनाओ. ओके, नाउ प्लीज व्हेन यू कम टुमारो, come after reading them and something on article 15 16 पढ़ के आना थोड़ा बहुत. Okay, thank you very much.